Hi crypto champions, today we'll talk about the court sanctions against the SEC, lawyer John Deaton's viewpoint on it, and his insider acquisition of XRP. Let's get going. The first news story begins like this, and as the court threatens to penalize the SEC for lying, Deaton responds. John Deaton, a well-known legal expert, explains why courts have continued to accuse the Securities and Exchange Commission of lying. XRP holders lawyer John Deaton has taken to the X stage to respond to a government taking steps to endorse the SEC's legal counselors engaged with the body of evidence against crypto task depeg. SEC lawyers face sanctions from the court. In the depeg lawsuit, SEC lawyers were given a warning by Judge Robert Shelby on November 30 that they might face sanctions for convincing a court to freeze the company's assets under false and misleading pretenses. The SEC made the claim that depeg was closing its accounts and moving its funds abroad in an effort to obtain a temporary restraining order. In any case, the SEC wouldn't specify that depeg's records were being shut by banks. The controller likewise neglected to take note of that the assets were moved to a credit association and not out of the U.S. Following the SEC's case, a government court froze the organization's financial balances in August. The judge dissolved the temporary restraining order after depeg demonstrated that the SEC lied in order to obtain it. Remarking on the turn of events, Judge Shelby brought up that the SEC's distortion caused depeg's hopeless damage and subverted the honesty of the case's procedures. Subsequently, the court took steps to authorize the SEC's attorneys for the situation. Courts get down on SEC for lying. Attorney Deaton responded by stating that every court that has dealt with the SEC in the past 3 years has accused it of lying. According to Deaton, no one has been paying attention in the past 3 years to the threat made by a federal judge to fine the SEC for lying. The entire article won't interest me. It would be time-consuming. Assuming you need, you can peruse it yourself. I will show a couple of tweets from it, and I'll continue on toward the editorial, where I will feature the central matters. Okay, according to legal expert John Deaton, recent developments in a case involving the SEC and depeg demonstrate the growing trend of judicial review of the SEC's approach to cryptocurrency cases. There are numerous reasons why these developments are significant. First, as demonstrated in yesterday's video, why repeat myself, the SEC's actions in the depeg case, in which they were accused of misleading the court to seek a temporary injunction, demonstrate an aggressive and possibly excessive approach to cryptocurrency enforcement. The news is connected because the SEC cases all follow the same pattern. The comments are also similar as a result of that, up until the situation improves or deteriorates. The way that the court is thinking about endorsing the SEC for deception is huge. If the courts consistently accuse the SEC of alleged misrepresentations, it calls into question the SEC's tactics and overall strategy for regulating cryptocurrencies. This demonstrates that the judiciary is willing to hold the SEC accountable for actions that may be deemed inappropriate. The SEC's credibility and efficiency in dealing with digital assets could be harmed as a result of this. This point is emphasized even more by the 4 cases that Ripple General Counsel Stuart Alderoty cited. The judiciary has questioned the SEC's approach in a variety of ways in each case, including allegations of hypocrisy, inconsistent arguments, and failure to comply with the duty to respond in good faith. The SEC should reevaluate how it regulates the rapidly evolving cryptocurrency market in light of such judicial rebukes. These developments have significant repercussions for the cryptocurrency market as a whole. The cryptocurrency market's uncertainty and volatility could rise if the SEC is thought to be overly assertive or inconsistent in its regulatory actions. In addition, if investors and businesses believe that the regulatory environment is hostile or unpredictable, it could stifle innovation. In conclusion, these developments point to a turning point in the regulation of cryptocurrencies. They emphasize the need for the SEC's regulation to be more balanced, transparent, and consistent. A strategy of this kind will not only help the law stay true, but it will also help the economy grow in a healthy way. Based on insider information, an expert denies buying XRP in response to the following news. John Deaton, a lawyer who supports XRP, has made it clear that he did not act on insider information when he decided to buy more XRP after Ripple was sued in 2020. The price of XRP experienced a significant decline as a result of legal action taken against Ripple in 2020. Many holders of XRP feared the worst for the cryptocurrency. The US SEC had named XRP a security and documented claims against Wave and its chiefs, Brad Garlinghouse and Chris Larsson. However, a crypto-focused attorney named John Deaton bought more XRP during the drop because he was convinced that Ripple would win the lawsuit. Yet again now, John Deaton has safeguarded the move he made at the time while explaining that was not in light of any insider data. In particular, Deaton was answering to a clear crypto financial backer who claimed that the legal counselor's XRP buy might be viewed as a type of insider exchanging. Symbio, a former user, said that Deaton buying XRP when he already had the case would be considered insider trading. Having the case taken care of obviously implies that the legal counselor was persuaded that Wave would arise successful toward the day's end. Deaton asserts that there was no inside information. Deaton points out that despite Ripple's successive victories over the SEC and the withdrawal of lawsuits against its executives, this outcome was not what many people had anticipated. In point of fact, numerous additional seasoned securities lawyers asserted that Ripple would not win easily and that XRP would be considered a security. Deaton, on the other hand, confronted the majority because he was confident that Ripple and the XRP army would prevail. In light of the intricate interplay between litigation and investment decisions in the cryptocurrency market, John Deaton's defense of his decision to acquire additional XRP after Ripple was sued in 2020 is noteworthy. First, the question of whether Deaton had access to confidential information about Ripple's legal prospects is at the heart of the insider trading charge. However, Deaton's argument that his decision was not based on insider information but rather on his legal analysis and belief is crucial. Understanding the distinctions between informed speculation and insider trading is also essential in the cryptocurrency industry, where changes in laws and regulations can have a significant impact on market sentiment. The market's sensitivity to regulatory action can be seen in the substantial price drop of XRP following the SEC lawsuit. Deaton's to put in the midst of this slump having confidence in a lawful triumph for Wave was a strong move. It shows that he is absolutely certain of his comprehension of the legal landscape surrounding XRP and the actions taken by the SEC. Notably, investors frequently make decisions based on their interpretations of events in the cryptocurrency market, and I would advise you to do the same. Deaton's decision to bet on himself and Ripple's legal outcome is a common scenario. This is especially true when, as is the case with many cryptocurrencies, the legal and regulatory environment is still in the process of changing. Let's move on to the chart now.